The senator from Spartanburg. Senator McCoy, he refuses. Senator McCoy.
Thank you. Thank you for all that you've done in medical marijuana. And for Ms. Richardson, I sincerely appreciate that. And I want to help you with Ms. Richardson. But let's suppose on the other side over there we got Cheech and Chong. Okay? I want to make sure that what we do here doesn't help the Cheech and Chongs of South Carolina. Do you agree with that?
I do, and the reason I agree with you, Senator McCormick, is I think that's what South Carolinians want. I think they want to help the Mrs. Richardsons, but they do not want to authorize legal or adult or recreational use. And so that's my objective, and that's a way of phrasing it.
And I want to work with you. But there's several things I want to talk about. First, are you familiar with the doctrine of comity? C-O-M-I-T-Y.
C-O-M-I-T, yes, I am.
All right. And could you explain that to the body?
Well, the doctrine of comity, as I understand it, is between different sovereigns or different levels of legislature and Congress passing laws and South Carolina passing laws. The doctrine of comity encourages them to be read in harmony, is my understanding of it. And that may be an imperfect one, but that's my understanding.
And that's a clean statement of what comity is. So as a matter of public policy, South Carolina can adopt a comity approach to this legislation, or it can be opposed to that. Would you agree with that?
I guess I would answer the question this way. Because the Controlled Substances Act, which is the federal law that we're working with here, as opposed to state laws that are in this space. I mean, so for purposes of comity discussion, those are the two different types of laws we're talking about, the Controlled Substances Act and the state laws. I do not think, and courts, cases that have considered it, have not concluded that passing of medical cannabis laws constitutes a lack of comity with what the federal government has done with the CSA, because the CSA on its face expressly says it is not intended to preempt state action in the space of controlled substances, and because in its operation, medical cannabis laws do not make enforcement of the federal law impossible, so that there's no obstacle or implied preemption either. So I guess I would answer it by saying I don't view the adoption of a medical cannabis law to be a violation of the principles of comity.
All right, and that's fine. But I'm talking now also about public policy. What is South Carolina's policy? In your earlier statement, 3 days ago maybe, you made the statement that South Carolina was behind on the question of medical marijuana. You remember saying that? I
do, and I made the statement in the context of there are 37 states that have legalized cannabis for medicinal purposes, but I would also state that back in 1980, South Carolina passed a medical cannabis law, but the body of that law incorporates or embeds in it that the state can take action in regard to making medical cannabis available to patients if it's okay and authorized by federal law. Okay, that's embedded in that 1980 Act. So I don't. I mean, that really is kind of a dead letter, which is why you never saw anything done with that 1980 law, because action by DHEC in that law was predicated upon a rescheduling of marijuana as a Schedule I drug. So I don't count that as being ahead of the game in that respect. Although what I wish they had done back then is passed a medical cannabis law that said, irrespective of it being a Schedule I drug at the federal level, we authorize DHEC, or we want to allow businesses in South Carolina to make this available to patients who are authorized by physicians to take it.
Well, again, this completely took care of the issue as it related to questions of cancer, as it related to questions of chemotherapy, and as it related to the question of glaucoma. Back in 1980, this legislature, this body, recognized the importance of allowing South Carolinians to explore these substances, correct?
But it did so, Senator McCormick, in a way that said DHEC could not take action and citizens of South Carolina could not access medical cannabis unless it was in accordance with the federal government rescheduling from a Schedule I to a Schedule II. So it really, I understand your point. We did pass a medical cannabis law back in 1980, but the reason it's been a dead letter, the reason that it hasn't led to any availability of cannabis to people who need it, is because it is tied to that Controlled Substances Act scheduling of cannabis.
Okay, so again, I found the word federal some 20 some odd times maybe in your bill. And for something that has been preempted as you have made this argument, then why we keep talking about federal in our state law?
Because individuals, and yourself in Medical Affairs Committee, have raised concerns about whether it is violative of federal law.
It is, isn't it? You agree it is?
It is not. It is not, for the reasons that I've stated, because preemption has not taken place in the CSA. And it bears repeating here as well. Every year, Congress passes a budget proviso that says the DOJ can't spend any of their appropriated funds to challenge states that have medical cannabis laws. So to say somehow that what states are doing is in violation of federal law, if that were the case, you would see injunctions issued by federal district courts against states that have medical cannabis laws. That hadn't happened.
Somebody's got to file it, don't they?
But when the challenges have occurred, and in the Arizona case that I cited,
well, let me ask you that.
Let me just finish the question. In the Arizona case that I cited, when a challenge did occur on the grounds that this is violative of federal law, the court concluded in a decision reciting Supreme Court cases that it was not.
You talking about Arizona, a state court case or a federal court case?
It was a state court case.
State court
that
case.
applied federal laws of preemption.
All right, that's a state court case. I got a United States Supreme Court case I want to talk to you about in just a moment.
Okay.
But under the CSA, you didn't read the entire CSA because there's a bottom, an end to that. After the CSA talks about it's not going to preempt the field, it's not going to preempt. Then it says at the end, and have you got it with you there?
I've got a copy of my preemption section here. I don't have the entire CSA Act.
Well, let me read this to you and tell me whether or not this is in the law of the CSA. You read part of it, but the rest of it is the rest of the story. No provision of this subchapter shall be construed as indicating an intent on the part of Congress to occupy the field in which that problem operates, including criminal penalties, the exclusion of any state law on the same subject matter, which would otherwise, within the authority of the state. Then it says unless. And that's the part you didn't read. Between that provision of the subchapter and the state law, so that the two can't stand consistently together,
And let me take that point.
there should be a presumption in favor of preemption where a state law interferes with Congress's ability to regulate interstate commerce, including drugs. Let me ask the question first. Isn't that in the rest of the story as it relates to what CSA said?
That is what it says. And let me answer your question. And in the case that I cited, okay, the Arizona case that applied federal preemption law, it said that state medical cannabis laws do not prevent the federal government from enforcing the CSA, does not prevent a single federal agent from coming down into states and saying that this is a controlled Schedule I substance, and therefore the court ruled that there was no preemption. There wasn't the interference that you just talked about. And so my point is, I think you're making my point for me, is that not only does it say expressly they don't intend to preempt the field, it then quite logically says, okay, but you can't have implied preemption either. You can't pass a law that says in South Carolina, federal government, you can't enforce the CSA in South Carolina, and any attempt to do that is going to be met with force by us. That would be an implied preemption. It would be impliedly preempted, but that's not what we have here.
This whole preemption thing is a rabbit hole. Look, do you agree with me, counsel, that the Supremacy Clause controls all of this? Do you agree with that? The United States Supremacy Clause.
There is a Supremacy Clause in the Constitution. What I will say to you is, I'm going to finish my answer,
yes,
okay?
Go ahead.
I have researched the case law in regard to if and when federal laws preempt and preclude state action. Okay. In the case of medical cannabis laws, it is not preempted expressly in the CSA, nor is it preempted impliedly, because there's nothing in medical cannabis laws that prevents the federal government from coming in and enforcing the Controlled Substances Act. There has not been, point me to one decision where a state medical cannabis law has been struck down and held invalidated because it is in violation of the CSA and makes it impossible for the federal government to enforce it.
Gonzalez versus Raich.
That didn't strike down a medical cannabis law.
I hate to tell you this,
No.
It is the Supremacy Clause case. It was a 6-3 opinion, 2005 opinion. In that case, we had two individuals, two females, growing dope. And as they were growing their dope, the sheriff's department, Butte County, I believe it was, California, and DEA flew over and saw the cannabis. You can see it from there. And so they went in and they destroyed it.
Okay.
Well, of course,
Sure, they can do
Angela
that.
Ray and,
Sure.
was upset, and I believe that lady's name was Diane Munson, and so they were upset. And they said, wait a minute, federal government can't come in here on our private property and take our drugs. And then the United States Supreme Court didn't even get it yet. It went up to the Federal Court of Appeals in the liberal side of California. And then the federal court, the federal district court, said, you're right.
Of course they're right, Senator McCormick. Of course.
Well, let me finish
Yeah, sure.
with a question. So as they went through that analysis, then the district court agreed. Then it went to the federal circuit court and the Ninth Circuit. And they said, yeah, they can't do that to you. You got medical cannabis rights. They can't do that to you. And then the United States Supreme Court said, oh, yes, they can.
Of course they can.
And they said in 6-3 opinion, Justice Stevens writing the opinion, Justice Scalia coming in and backing up that opinion,
Sure.
said this, said that under the enumerated powers, the federal government, under the Commerce Clause, intrastate and interstate, the federal government has a right through CSA to protect against the growing and carrying on of the medical marijuana.
They do.
I understand they do.
They do, but that has nothing to do with the argument about whether or not a state law is precluded from being enacted.
It was shut
doesn't have anything
down
to do
as
with that.
against the CSA.
What's
The
that?
supremacy of the United States was established in this case, and this is still good law.
No, Senator McCormick, okay, we're talking across purposes here. I acknowledge the supremacy clause in the Constitution. I acknowledge that the Commerce Clause empowers Congress to take action. I don't make the argument that the Controlled Substances Act is unconstitutional. I don't challenge the fact that DEA or federal agents have the right to enforce the rules of CSA like they did in the case you just said.
Okay.
What I'm saying is that has nothing to do with the issue of whether or not a state medical cannabis law cannot be enacted because it's been preempted. That's a different legal theory you need to explore there. You're mixing apples and oranges. Sir.
No, I've read this. It basically looked at the California law, which is a medical cannabis law, and said it's trumped. I'm sorry, it's
Of course it is. And if there's anything in that law or in any state law that purports to tell the federal government that they can't do what those DEA agents did, then that law is invalid because it's violative of the Supremacy Clause. What I'm saying to you is, in the 37 states that have enacted medical cannabis laws, and in this particular legislation, there is nothing in here that provides protection for an individual or a business from having the federal government coming in and saying, this is illegal under federal law and we're going to seize your marijuana. They can do that. They can do that. If we passed a law that said they couldn't do that, then I would agree with you. Then that is something we can't do.
Well, this is why I'm interested in, again, you've cited federal law some 20-some times in your bill, and then you put a provision in here that I thought was very interesting, and I want you to kind of explain
Which section, sir?
what you meant by that. It had to do with in the event it was overruled or
Yes, at the very, I think it's probably going to be, it's at the very, very end, Senator McCormick, but it was part of the committee amendment. So depending upon what you're looking at, it might be at the very beginning as a committee amendment, or if it's in the body of the bill now, it's at the end.
Right. And what I want to ask you about is that you set out, if this happens, then the $15 million that the state of South Carolina has spent getting this set up is just going to evaporate and go away because you said you'll shut it down. Is that correct?
That language was added, and let's just go ahead and read it for the benefit of the body.
Go ahead.
Sections 1 through 8, which is the entirety of the bill, shall be repealed by operation of law if a federal court pursuant to a filing by the United States of America
Can I stop you there?
Yes, sure.
Because I want to go through each of these things you say have to happen before your bill then is illegal. You would say if a federal court, is the United States Supreme Court a federal court?
Of course it is.
Okay, and then you said pursuant to a filing by the United States of America, and
Or one of its authorized executive agencies.
and was Mr. Gonzalez at that time the Attorney General for, I believe it was President Bush?
At what time, sir? I'm sorry.
At the time that the Gonzalez 2005 case was announced by the United States Supreme Court.
I think he was. That was the AG at that time.
All right, or one of its authorized executive agencies, you would agree with me that DEA enforcing
Is an authorized executive
CSA through Gonzalez would meet that requirement, issues a final order by the federal order, and it said declaring that those sections have been preempted. And so that's the language that you're using. In the analysis between you and Chip Campson, the senator from Charleston, did I not hear y'all talk about the issue of preemption back and forth about the issue of various types of preemption? I didn't hear you talk about something called obstacle preemption.
I did talk about obstacle preemption.
You did?
Yeah.
Okay.
That falls into the subcategory of implied preemption.
Which is another type of...
Obstacle and impossibility are the two components of implied.
And there appears to be numerous legal opinions on both sides of that as to whether or not the medical cannabis law has been preempted. There seems to be various studies both ways by legal scholars.
Well, let me say this.
To that effect.
What we don't have is a decision by a federal district court striking down a state's medical cannabis laws as being violative of the supremacy clause because Congress has preempted the field. I mean, show me where a state law has been struck down by the federal government arguing that the CSA preempts the field either expressly or impliedly.
I'm sure you've read by now Gonzalez.
Yeah, but that case did not involve the federal government coming in and shutting down a state medical cannabis law. It involved.
Did they not declare, Senator, they not declare, and you and I can, we'll calm down about this,
Sure.
But did not the United States Supreme Court declare that the CSA was supreme to the California medical cannabis law?
Of course it is. And that's why. Let me finish. You asked me a question. Of course it's supreme into the areas that it speaks. And there's nothing in this bill that prohibits the DEA or any other executive agency of the federal government from coming in and enforcing that CSA Schedule I prohibition and seizing the cannabis. There's nothing in here that blocks that.
Look in here as it talks about the medical cannabis as it relates to possession and cultivation, which is part of the CSA.
But
here
it
you
relates
got the
to
United States Supreme Court saying against the California law, you can't possess it.
No,
you can't grow it.
We're in violent agreement here. Okay. There is nothing to prevent the federal government, even if this law were to pass. Okay. Let's assume this law were to pass.
Okay.
And you got medical cannabis establishments, you've got growers, you got processors, you got dispensers, you got whatever. Okay. There is nothing to prevent, assuming that Congress doesn't continue to keep in the budget saying you can't use the money to do it. Okay. There is nothing to prevent the federal government, nothing in this law that would prevent the federal government from coming in and taking your cannabis. Because you're right, the CSA is a federal law. It's the supreme law of the land. Nothing in this bill can constrain or restrict the federal government from enforcing that law. But what I would say to you is that hadn't happened in the 37 states primarily because Congress every year says to those federal agencies, you can't use any of the money we give you to do exactly what you're postulating here. But your point is well taken. It is the supreme law of the land. The Controlled Substances Act is going to trump this law. Okay. When we talk about, criminal penalties and exemptions, we're talking about in regard to state law. We're not talking about federal law. We don't have any ability to nullify federal law.
So as I began the discussion about comedy, as a matter of public policy, do we want to write laws that are completely contrary to the federal law?
Well, we did it last year with the heartbeat bill.
That's a different issue because that's a fundamental constitutional right. You're not telling me that you think that somehow medical marijuana is a constitutional right.
You didn't phrase your question in those terms. You phrased the question in the terms of, as a matter of comedy, should we be passing a law that's in violation of federal law? That's right. How you phrased your question.
That's right. But the same point. Does two wrong make a right?
I'm answering your question about comedy, okay?
Okay.
And what I would say to you is, in terms of comedy, okay, if it in fact was the case that the Controlled Substances Act either through express preemption or implied preemption in the subcategories of obstacle and a possibility, if it were in fact the case, as I think that you're trying to argue, that these state medical cannabis laws were violative of that preemption principle, you would see decision after decision striking down medical cannabis laws in states. There haven't been any. There haven't been any.
I haven't seen any lawsuits even brought.
And you know why? Because first of all, it is not prohibited by the preemption doctrine. Second of all, because Congress has said to the Department of Justice and its subsidiary agencies like the DEA, you can't use any of this money we're giving you to challenge state medical cannabis laws.
Yeah, if you'll look at that too, I went back and studied that. It's not necessarily what it said. It said we will not use the money to prosecute patients, sir.
We'll read it. I'll read it right now.
Go back and look at it. I'll call it out to you as well. It talks about patients.
Here's how it reads. None of the funds made available under 4 of this Act to the Department of Justice may be used with respect to any of the states, and then it lists all the states, and then at the very end it says, to prevent any of them from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. I'm reading it verbatim to you.
Okay.
I'm not trying to pull any punches. It is what it is.
You and I can tell you this, Senator, you and I will never do that against one another. I'm not that type of lawyer, and I don't believe you are.
I don't suggest that you are, but I read that, and it's fairly straightforward. None of the funds made available to the Department of Justice may be used with respect to any of the states, and then it lists all the states that have medical cannabis laws, to prevent any of them referring back to the states, from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana.
What year are you reading from?
I'm reading, it's the Rohrabacher-Farr Amendment that Congress has passed in each budget cycle since 2014. The current one is in connection with the continuing resolution that Congress is operating under.
I'm looking at Eric Holder's statement, basically, of 2009, Eric Holder being the Obama Attorney General, who basically said that issued new guidelines allowing for no enforcement of the federal ban in some situations. He basically said it will not be a priority of use of federal resources. It said to prosecute patients.
What you're confusing, though, Senator McCormick, is the Cole Memorandum, which is what that's referring to. Okay. I'm reading the budget rider that Congress passes. And so the 2009 Cole Memorandum that gave prosecutorial discretion or advice to U.S. attorneys, that's not what I'm citing here. That Cole Memorandum was withdrawn.
But isn't that, that's the reason they stopped doing it in 2009. But let me read to you what their philosophy was as to why. It said it was not be a priority of the use of federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana, but we will not tolerate drug traffickers who hide behind claims of compliance with state law to mass activities that are clearly illegal. At least that was the public policy of Eric Holder during the Obama administration, that he wouldn't punish the patients. But he certainly didn't say that he would not punish grow fields, processing plants, transporters, dispensaries.
But again, let's just be clear. When I'm reciting what the prohibition the DOJ is operating under in regard to use of funds, that is the current law. What you're reciting from in 2009 is what's referred to as the Cole Memorandum, which was advice given to U.S. attorneys. So I've not mentioned the Cole Memorandum in the time that I've been up here at this podium, because I wouldn't want to mislead this body into thinking that that was somehow an exposition of what the federal government is saying in regard to state cannabis laws. This is a much better, cleaner statement, what Congress actually passes every year.
Would you agree with me that tomorrow they may do away with that law? They may not put it in the proviso coming up. The General Assembly of the United States of America may not put that in the budget proviso coming up.
I guess that could be, but as a matter of course, for the last 8 years, it's just rolled into the bucket.
Fine, but let's talk about what happens. We've got this $15 million of our state money. We're trying to cut taxes and we're trying to cut the size of government.
What $15 million are we referring to, sir?
Sir?
What $15 million are we referring to?
The budget impact of this medical marijuana.
Well, we can talk about that at some point because I think the estimate that SLED provided in regard to, and let's get into that because I think it speaks to good faith. SLED isn't really required to do much of anything in this bill other than to consult with medical cannabis establishments in regard to security and things of that nature. They say they need 78 new employees establishing 2 new units. What the heck are they going to do? Are they going to drive around? Are they going to go ahead and surveil every medical cannabis establishment in the state 24/7?
Senator,
But bottom line, since we're talking about fiscal impact, I'll stand by what I said earlier.
Okay.
There are going to be some upfront costs that this general fund has to take care of to get the program up and running, but every single state that has adopted a medical cannabis law does not only does it not have to get money from the general fund long-term to cover, it generates surplus revenues because of the economic activity and the revenues that are coming in through the sales tax. And I'll stand by that.
and we can talk about revenue raising taxes and whether or not that should start in the House or whether that should start in the Senate.
Well, let's talk about it now. Let's
another
talk about
time.
it now.
I'm not
Raise the
prepared. I'm not prepared, Senator.
Raise the point.
And I'll be happy to say that I'm not prepared to talk about it on that question. I'll leave that to some others because I'm just not adept.
Senator from Darland.
Parliamentary inquiry.
State your inquiry.
So there's a reference as to whether or not that this is a revenue raiser which will start in the House of Representatives, but I'm trying to be certain that there's not a point of order being raised, and the second part of that is that parliamentary inquiry is that are we on an amendment that address any issue as it relates to tax?
We're on the, there's been no point of order raised, and we're on the explanation of the bill. No amendment.
There's
before
no
us.
point of order. You haven't raised a point of order.
I have not raised a point of order.
I guess, that's
Senator
fine.
from Beaufort is
If
right.
we want to have that discussion and we want to talk about what the Constitution allows and whether or not the primary purpose of the bill can have revenue raisings, I'm ready to have that argument if you want to have it.
The budget office said it's going to cost us $15 million. Would you disagree with that?
I do disagree with that.
Okay. How much does the budget office say this bill will cost to implement?
The fiscal impact that was issued is in 2 components. You have DHEC indicates that it needs in initial expenditures given the potential for lag in revenue collections. Okay, so this talks about initially. DHEC expects to rely on general fund appropriations of $5,034,000 to establish the program in fiscal year 2022-2023. For fiscal year 2023-2024, DHEC indicates that other funds from fees and monetary penalties will fund the expected $3,045,000 recurring appropriation. So after the first year of operation, DHEC is projecting that the fees and monetary penalties and funds of that nature will cover their recurring expenditures. So, and I've been frank up front, there is going to be an impact one time to the general fund as this program is stood up before you start having people, using the system and establishments operating. Where I object, quite frankly, is the state law enforcement indicates the need to establish 2 new units with 78 FTEs to manage the requirements of the bill. They're not required to do anything. I mean, DHEC is in charge of this program, okay? Now, certainly law enforcement is in charge of making sure that the law is followed. So if you have diversion of medical cannabis for recreational use, if you've got somebody in possession of an amount of cannabis that's not allowable under state law, if you have individuals who are consuming medical cannabis in public, which is prohibited by this law, there are any number of instances where if you're in violation of law, like every other law we pass, law enforcement can arrest them. But to say that you need that many new FTEs in order to discharge the requirements of the bill, they aren't required to do anything.
I want to get back to the easier route and talk about the 1980 Therapeutic Act as well as Julian's Law. Now, you did participate in Julian's Law, didn't you? 2014 law.
I drafted that law.
So, I mean, again, at that point in time, the General Assembly also was again exercising as a matter of public policy comity between the federal and the state, and y'all were trying to, as I read that, you were trying to get through the 3 or 4 different types of epilepsy that there was some alleged, and there may be now proven benefits of cannabis oil, or whatever the product is, THC or CBD, to help with the epileptic circumstances. Fine with that. And again, I'm trying to help you over here with
No, I appreciate this.
people that really need it. I'm with you. Okay? Now, let's take it a step further.
Okay.
Now, you're talking about doing this in small steps. You use the word, I want to do this in small steps. Senator, 15 grow fields?
Excuse me?
15 grow fields?
Yes, 15 grow fields.
Where did that number come from?
I've looked at what other states have authorized in terms of the number of establishments, growers, processors, dispensers. I've looked at the population in those states and tried to correlate it downward to conform with our population. So I tried to define a relatively narrow universe of medical cannabis establishments. And unlike, quite frankly, Senator McCormick, other states have not. Some states have not put any restrictions at all. It's just the Wild West. You file your application, you get out there and you do a grow.
Senator, I'm not asking about other states. I'm not worried about that.
What I'm telling you is why I'm saying it's conservative. Our state limits it, and I don't think 15 is a huge number of grow facilities. I mean, maybe you and I disagree about 15.
How large are these grow facilities?
I don't know.
How many acres?
I don't know. It depends on the applicant and what's approved by DHEC and the capital that they have and what their business plan is. I don't know. I don't get into the micromanaging of that.
Are you aware that in Florida, they had 8, and they're trying to reduce the number of grow fields from 8, and here we are in South Carolina asking for 15? Certainly, there's a lot more people in Florida than there are in South Carolina wanting to use medical cannabis.
In looking at the other states, I consider 15 cultivating facilities to be a very modest number.
All right. And let's move on to the next thing. You said we need 30 processors. So I'm assuming why do you need 30 processors?
Again, I'm looking at what establishments, the markets are doing in other states. Okay, we have experience of being able to look and see how this, let me finish my answer. We have the advantage of looking at what those states have actually done, how it's worked. You know, what have been the ratio of grow facilities to processing facilities to dispensaries. And so I have tried to look at what other states have done, to look at what has worked efficiently, and then extrapolate that back into our state, accounting for adjustments in population. That's how I came up with those numbers. Now, if there are different numbers that you think are better, or that you think are more manageable, or you think there's a more of a rational relationship between those numbers and the population of South Carolina, let's put up the amendment and let's debate it. I'm telling you how I got to these numbers.
Okay, thank you for that. And then, as it relates to these processing plants, I guess you got 2 for 1 for every grow field. You got 2 processing plants. Is that where you got the 30 number?
The 15 times 30 is twice. Times 2 is 30. Yes.
2 per, probably. Okay, to get to the 30.
15 times 2 is 30.
Okay?
Yes.
And then you've got the transporter circumstance, where I'm assuming that we're talking about a lot of cash and a lot of dope, and protecting that in some way to get it from point A to point B.
I wouldn't call it dope, sir. It's medicine. Okay.
For her, it's medicine. The ones I'm worried about over here, Cheech and Chong, is dope.
All right. Let's explore that for a moment.
Okay.
Cheech and Chong.
Okay.
They like to get high. Or they used to. I don't know if they do
I
anymore.
would say for sure they like to get high.
So a lot of people smoke dope.
Right.
All right. They go out there, they buy marijuana, roll it in a joint, smoke it in a bong. You know, they smoke it. Okay. If you're that person, why in the world, instead of going out and buying cannabis for your personal consumption, which will be a misdemeanor, why would you instead go through this process, lie to a physician, commit a felony, to purchase something that's much more expensive than what you could buy on the street? I mean, what rational actor would pay more for something and subject themselves to a felony? It doesn't hold up.
I'll tell you a quick story.
Okay.
I was defending a fellow who was charged with murder, and one of these other fellows that was with him was also charged with murder, and they were charged with aiding and abetting one another and killing this fellow at McDonald's. And he got up on the stand, and I asked him, had he had any drugs? And he said, well, yes. I said, well, what kind of drugs did you have? And he said, well, I had a blunt. And, of course, I'd never even heard of a blunt. So
joint.
I'm in the middle of a trial of a case. I think I had a judge out of Greenville was there, tough judge. Anyway, this guy gets to there and he explains this blunt situation. I said, well, what is it? He said, well, you take a cigar and you split it down the middle and you take all the tobacco out of it and then you put the marijuana in it, okay? And then you close it up and you smoke that, that's a blunt. He said, well, they smoked several blunts, along with cocaine and all that before all this happened. So that was why he couldn't remember all what happened. So that was my first introduction to blunt. So let's get back to Cheech and Chong for just a minute.
Sure.
Those folks are the folks that I'm worried about. And here's what happens. I have practiced criminal law for 39 years. I've represented so many people charged with marijuana and these mandatory minimums. And I'll talk to you a little bit about your bill here as well. And, you know, these people, they're going to smoke their dope. And what they're going to do with this dope, if you let that group, Cheech and Chong, not only, you know, your earlier bill, and I understand y'all have changed that now, allowed people from out of state to come to South Carolina with a medical cannabis card and get marijuana in South Carolina. And we had reciprocity, I believe, where our people could go to other states and get marijuana, right?
That was in the bill, but as you rightly note, that is something that, you know, in an continuing effort to be constructive and responsive to express concerns,
I thank you for that, and I've got a little concern about that under full faith and credit from state to state, to be honest with you, from a constitutional point of view, but that's something I guess that could be looked at and dealt with. But what's going to happen is these people are going to take these blunts and they're going to take this THC that's at such high concentrations that, yeah, it costs more, but it's substantially much stronger than the little 2 or 3% that they've got. And they're going to take that oil and they're going to put it over that marijuana cigarette, blunt. Maybe. I mean, I don't do it, so I wouldn't have a clue.
Yeah.
But I listened to what he said, and I wrote it down, and I watched it. So what I'm concerned about is whether they're vaping it, you know, if they get a hold of it illegally, improperly, then those people, you know, this is a lot bigger footprint. I'm worried that this is a basis to bring recreational marijuana to South Carolina. What you said, it's not your intention, and I believe you, but I believe your small step is so large that there's another way. There's another way here in our existing law if we modify it. We add your people, Ms. Richardson, and every class of person that needs to go here. And then we try to help them with medical cannabis. And we follow the federal rules and regulations. There is an easy way to get a clinical study done.
I respectfully disagree with you, sir.
Okay, well, let me ask you this. What really concerns me also is that the doctor doesn't even have to participate in a study. It says may.
Participate in what study, sir?
In any study. I mean, I thought we were doing this to learn science, to be able to help people.
So are you suggesting this bill should be amended to conscript doctors into participating in studies against their will?
Well, why would it be against their will if they're trying to help Ms. Richardson?
Well, we can require them to do certain things in terms of continuing medical education, because I think that relates to their qualifications, but I don't think that we can compel them to participate in studies. I mean, we can have a discussion about what baseline of knowledge you want physicians to have in order to be an authorizer. I would suggest to you that compelling them or conscripting them to go into and participating into some unnamed study really isn't something we want to do.
Well, and then you don't even have these patients part of the study. Why is it required that every patient who's going to receive medical cannabis be made to be part of a study so we can see the efficacy of your brainchild? I mean, I really want to see it happen. I really want to see us find 15 things that it solves. Counsel, I really do.
Yeah,
and there's a way of doing that, but you got to do it with controlled studies, and the federal government has got a method for us to follow to be able to do that lawfully. You know, and we don't make everybody criminals.
They don't, sir, because if that were the case, you wouldn't have 37 states that set up a medical cannabis law, okay? They'd be doing what you're suggesting, which is not possible.
Well, In Julian's Law, tell us about that. Did you
Julian's Law, what we did was we recognized that individuals with epilepsy were responsive to cannabis treatment, particularly cannabis that was heavy in the CBD strain as opposed to the THC strain. And what we did in that particular law is that we allowed a doctor to authorize an epilepsy patient to consume cannabis as long as it didn't have more than 0.9% THC in it. That's what we did in that particular law.
Okay. And did we do any studies on that?
I'm sorry, sir?
Any studies on that? Were any studies, clinical studies done in the area of this epilepsy in Julian's Law?
Not mandated by that law. There may have been studies done by MUSC or by USC School of Medicine or other that I'm unaware of, but I guess to your point, there's nothing in that 2014 law that compelled participation by those epilepsy patients in studies. Is that the question?
Yes.
No, there's nothing in the law that compels that.
Well, don't you think it would be very helpful to all of us, if we're going to spend money on it, that we ought to get the University of South Carolina, all these research institutes, let's get them involved in this. And let's set up clinical studies, and if you want to get into the medical marijuana field, fine. You gotta go through and sign up for the study. And then, if you have one of these maladies, whatever it may be, suppose it's chronic pain. Well, fine. You know, you've been using opioids. I've heard your arguments about opioids versus cannabis. Okay, and I'll tell you about that in just a minute. But as it relates to that, I mean, these people that are using it, you know, they need to be able to say how they're feeling. If it's subjective, it's not objective, it's subjective as to how they're feeling. How are we going to know, how are we going to help the doctors know, the physicians, the pharmacists know, as to what quantity we give these people for those 14 days?
Well, presumably the physician and the patient are going to discuss that. Presumably the pharmacist is going to discuss that with the patient. I don't know how you get to the result that you're articulating there by having them participate in a study, okay? And to the point of studies, there are hundreds of peer-reviewed scientific studies out there taking place throughout this country. So the notion that somehow doctors and physicians don't have access to peer-reviewed studies to understand what the efficaciousness of cannabis can be for medicine isn't true. There are lots of studies out there. I have several of them in my binder.
I've got a lot of studies on the reverse side of it. You and I both.
And I know that book. And that book makes a valid point.
Okay.
And the point that he makes in that book, okay, the point he makes in that book is that for individuals who are disposed to have schizophrenia or disposed to psychological problems, they ought not have cannabis because there are demonstrated instances where, if they are, it can translate itself into violence. I readily admit that. And that's one of the reasons why it's so important for that patient doctor diagnosis to review somebody's mental history. Do they have a history of that? Because the book points out, and quite frankly, that book rightly points out that many states don't have what we have in this bill. Many of these states simply say, you can go out there and grow your own. You go out and grow your own marijuana. There's no physician involvement in the consumption of cannabis in a lot of those states. But what I'm saying is, let's look at our law. Let's look at what our law requires.
Let's talk about this then a little bit.
Okay.
I'm with you on your law.
Sure.
Okay. Let's talk about your law.
Okay.
Now, I'm talking about making everybody, both the doctors who participate in these studies, as well as the pharmacists, as well as these patients, to participate in these studies. Now, suppose, you know, you're calling this compassionate care, and when we look at her, I'm with you. I'm not with you, Cheech and Chong. Talking about compassionate care, I'm there. So if these people, I can't believe that Ms. Richardson would not want to participate in a study and help others with her malady and as to how cannabis has helped her, and let her explain and let her journal about how this is working for her. And all of that information gets put together. Now, suppose we get one of these kids. Let's just...
Okay, but can I respond to that about what Ms. Richardson might do?
Yes.
But it's up to her whether or not she wants to do that. Some individuals might not be comfortable doing that, Senator from McCormick, and I don't know why in a bill that seeks to empower patients and physicians, we have to include in there a requirement that the patient somehow participate in a study.
Well, because there's a lot of argument as to whether or not there are a lot of help from medical cannabis. I mean, there's studies both ways. Listen, I've seen them. You've seen them.
And I would agree with you. I would agree with you, and I suspect we're going to hear some of them. I am not saying marijuana is a panacea. I am not saying marijuana can solve all these conditions. Right. All I'm doing is saying that when that physician sits down with a patient, I would like this to be one of the options they discuss. It's up to that physician to decide whether it's appropriate for that patient to avoid the things that are chronicled in that book.
Let's talk about your bill calls for, and it's interesting if the person is under 25 to 18, I think it takes 2 physicians to participate. I didn't see anything in there from 18 down to, whatever, and I'm assuming that there are patients out there who will need to have a doctor's prescription for that as well.
I'm sorry, sir, for under 18?
Yeah, for under 18.
Yes, the guardian would be the one that would be the authorized caregiver in that instance.
Okay. And, there's a lot of stuff in here, a lot of work about guardians, and we can talk about that. There's a host of things that we can talk about. But I'm worried about this kid. He's shown no signs of any psychiatric, no psychosis, no schizophrenia. Smokes dope. In that case, it's dope, as far as I'm concerned. Now, if it's medical marijuana, and if it's measured out, and if the doctor's part of the study, and if the patient is part of the study, and if the pharmacist is part of the study, and we're all going to have all this information shared, with the university, then in 6 months, but what happens if he has an episode in 2 weeks? What happens if he goes, schizophrenic? As possibility based upon these studies.
I'm never going to say to this body that there can't be an adverse consequence to taking marijuana. I'm never going to say to this body there aren't going to be cases where physicians misdiagnose. What I will say, however, is whenever you're talking about public policy and deciding whether to do something, you weigh the instances where there can be bad outcomes against the benefits that accrue. We do that all the time. We do those trade-offs all the time. And so what I would say is that the likelihood or instances where there's going to be the reactions that you're talking about, okay?
Which is maybe as much as 20, 30%.
No, it's not. I can show you some peer-reviewed studies that talk about a 1% reaction to those things.
Relying upon this.
Well, that's a mystery writer, okay? He writes mysteries.
He did a pretty good job on this. I mean, you acknowledged
he made a lot of money on this thing.
Good. Okay.
But what I'm saying is, what we're doing as policymakers is we're weighing the benefits that would accrue to people under this bill, and you're properly pointing out, and fair enough, what some of those costs might be. And what you're articulating, it's fair enough for us to consider. Let's factor that in the weighing process. And I concede to you, there are going to be cases where individuals are authorized to get cannabis and should not be. I mean, for me to stand up here and say with 100% certainty that will never occur, that would be disingenuous on my part. So I don't dispute that.
Well, help me get there. Help me keep these Cheech and Chongs who have a headache, those Cheech and Chongs who have insomnia, those Cheech and Chongs who say, man, I got pain. I got pain, brother.
Senator McCormick, there is marijuana out there now.
I'm not talking about that.
We're not talking about the Garden of Eden and introducing the serpent into it. Okay, it's out there now, and they're smoking it.
Right. Oh,
okay, and look, and again, and I'll just say it again, and I won't anymore. It doesn't make any sense for somebody who wants to get high, a Cheech and Chong, who's going out there buying marijuana very easily, getting what he wants. It doesn't make any sense. Instead, for them to say, well, wait a minute, here's a good idea. Instead, why don't I try to go ahead and commit fraud and participate in a medical cannabis program and subject myself to a felony penalty where I can be in prison for 5 years to get something that's going to cost me a lot more than what I can buy down that street? It doesn't make any sense to me. And at some point in time, we have to make a judgment call in this body as to what is feasible and what isn't. I don't think that's feasible.
Well, again, all I can say is that I represented thousands of people over the years, and a lot of them went to jail.
Yeah, they smoke dope.
A lot of these people,
you're making my point. They buy marijuana,
and they will still do that. All I'm saying is, this lady right here, if she bought it, it was because she had to. She didn't have a choice. I'm opening that door for those people.
I'm
good with that.
I appreciate that.
I'm closing that door.
I don't want that door open either, Senator
Well,
McCormick.
then let's work together and figure out a way to make sure we close that door. And one of the ways to do that is to have everybody participating in our studies. Instead of talking about us, well, maybe it's right, maybe it'll work, maybe. Why don't we have exacting studies? We've got the greatest universities in the world, as far as I'm concerned, right here.
Let me stop. I am not saying maybe it's right, maybe it's wrong. What I'm saying is that decision is being made at the wrong level right now. That needs to be decided by a doctor. It doesn't need to be decided by us. I want to get us out of the medicine business and put it in the hands of a doctor where it belongs.
Well, and to that point, again, we get back to this federal thing. There's a United States Supreme Court saying that a physician cannot prescribe this marijuana because it's illegal. So, I mean,
You want to talk about that for a little bit?
Well, you know why this is so difficult? You know why we're having to go all the way around our toe to get to our eye is because we're dealing with a federally illegal substance, and there's a lot of us. My oath of office, you had made a comment about my saying that. When I read a Supreme Court opinion that says that it's not proper, I'm bound by,
Sir, when the Supreme Court case you're referring to is in regard to the Supremacy Clause, and based on the facts you gave me, involved DEA agents flying over, seeing marijuana, and going down and seizing that marijuana. Yeah. That is perfectly appropriate. There's nothing in this law that will prevent the federal government from doing the very same thing here in South Carolina. Now, in regard to it being illegal, since, we're citing cases, the U.S. Court of Appeals, a federal court of appeals, Ninth Circuit, and Conant versus Walters said that a physician had the authority to authorize a patient's use of medical cannabis, that was not illegal under the Controlled Substances Act. Federal Circuit Court of Appeals decision. Again, Conant, C-O-N-A-N-T, versus Walters.
Did it go to the United States Supreme Court?
It was not appealed to the Supreme Court.
Okay. Or they didn't grant cert to one side or the other.
There's no Supreme Court case. I don't know whether they petitioned for cert or not.
Liberal, that's where this Gonzalez case came from.
Please use your mic.
Apologize.
Yeah.
That's where that came from. The Gonzalez case came out of that same Ninth Circuit. So again, you got a bunch of liberal judges, in my estimation, who are not following the law. They did the same thing with immigration. And maybe we're to the point where none of us want to follow the law and not be no longer as a matter of public policy, want to be a rule of law state.
If you want to have a conversation about what the proper role of state and society is, we can have that. But I would suggest to you the position that you're taking with the state controlling and stepping into the physician-patient relationship, that's the very definition of statism.
I'm not saying that, look, I want a doctor to prescribe this for her, and I want a pharmacist like our good pharmacist there to fill it. And how do we get there? And how do we get there without violating federal law? How do we get there to that point? And whether we need one grow field or whether we need 1,000, I want to make sure that those people are taken care of, but I don't want those folks over there, Cheech and Chong.
Senator McCormick, you can't just make a statement saying that a medical cannabis law is violative of federal law without showing me a case where it's been struck down. No, you didn't show me a case striking down a medical cannabis law. You showed me a case where an individual said a state law provides me protection from federal prosecution, and it doesn't. Neither does this law. That's the case you cited to me.
Well, that case said, as a matter of the Supremacy Clause, it was talking about what? It was talking about the right of the state and the federal government. So it was a conflict. Jurisdiction, it was there. It was one state versus the United States in that issue, and it was under the race in her name.
And I agree with you. If there's something in a state law that purports to stop a federal government from enforcing the Controlled Substances Act, I agree. Strike it down. The Supremacy Clause says you can't do that. What I'm saying to you is, I'm talking about this law. I'm not talking about that case. I'm talking about our law, and there's nothing in this law that violates the preemption doctrine. There's nothing in this law that prohibits the federal government from enforcing the CSA.
Well, in fact, the United States can come in and prosecute everybody involved in this.
Of course they can. Well, with this restriction.
We put them in
wait. With this restriction. Not so long as that budget proviso is in there, because that budget proviso is very express in regard to what they can use the money appropriated to them for.
What happens if we get a Richard Nixon back in office? God forbid. Suppose we get a Jeff Sessions as Attorney General, and then he looks around and says, you know, I'm sick and tired of the United States of America and all of these people in these courts and whatnot not following the law. I'm going to go ahead and fix that border. I'm going to fix this abortion issue. I'm going to fix that gun issue. I'm going to reach over here and I'm going to fix this issue. And we're going to follow the federal law that has been preempted. We're going to follow that, and that's what we're going to do, okay? And if they did that, where have you left South Carolinians, Senator?
If they did that, then every single state that has a medical cannabis law and every single medical cannabis establishment in those 37 states and the more than 75% of the United States population that is accessing that medical cannabis, they'd be angry. Okay? What I'm going to suggest to you is what you're postulating.
That's Article 5 stuff.
But what you're postulating is politically, you know, fantastical. I mean, if they were going to do that, why haven't they done it? Why haven't they done it?
You've had 8 years of Mr. Obama and Mr. Holder.
No, we've had years of George Bush and Donald Trump. I mean,
After that, and Gonzalez was pursuing it.
But that wasn't, again, sir, it wasn't against a medical cannabis law. It wasn't against. It wasn't in regard to a law. I mean, we're not talking about a law that purports to block federal action. If that law did, if California or whatever that state is that did that, if they had in their law that this is going to shield you from the DEA from enforcing the CSA, you're damn right that's going to get struck down because it's violative of the Supremacy Clause. But that's not what we're doing here. You can't take a case like that and apply it here.
I hate to say that the United States Supreme Court has made it very clear that the cannabis law, the medical marijuana law of California, has been trumped by the Supremacy Clause of the federal court and CSA.
Of course
I'm sorry, it's here. I can't change the words.
We're in violent agreement here, okay? I'm not, if this law were to say somehow that we're passing this law and we're going to tell South Carolinians you're shielded now from the federal government enforcing the CSA, I would say you're right. That is not what this does. There's nothing in this law that prohibits the federal government from enforcing the CSA.
So you're going to expose every South Carolinian. We're going to expose every South Carolinian who participates in this that we know is a violation of federal law. That's what your intentions are here?
Yes.
All right. So
that's what the intentions are in the 37 states that have done this.
I'm not worried about those 37 states,
backed up by Congress every year saying to the DOJ, you can't enforce this law against these medical. They've acted. They've already green-lighted this.
If you've got enough states, then you go to Article 5 convention and you make it legal. Okay? Fine. That's a separate discussion.
We're just going to have to agree to disagree on this, Senator.
A separate day. Let me mention this to you. You know, I heard you say that, you know, cannabis is not addictive. Did I hear you say that?
Do I think marijuana is addictive?
Yes.
I don't think it's physically addictive in the way that opiates are. I guess somebody could be, in some instances, people might have a vulnerability to it, and perhaps they become psychologically addicted to it, or they like that so much. I mean, I'm not saying that can't happen. I don't think in terms of addiction, it's the same sort of addiction you're talking about with opiates or opioids.
Or alcohol.
Or alcohol.
Yeah. 49 people in Greenwood, according to my coroner, died last year of drug overdoses. 15 of those people had marijuana in their system. Now, here's my question. Do you think they started off with heroin before they ever smoked their first marijuana cigarette? Or do you think they started off with cocaine before they smoked their first marijuana cigarette?
So in the case you're talking about, in the opioid deaths, in 15 of those cases, there was both marijuana and opiates?
In every case, fentanyl.
Okay. So what was it that killed them? Was it the marijuana?
No, the marijuana didn't kill them. That's not the point. I'm not saying marijuana will kill you. I mean, look, it's like the secondhand smoke. Cigarettes will kill you. It's going to give you heart disease, and it's going to kill you in the long term. The studies haven't been out yet on medical marijuana, so we don't know the ins and outs of that. I know you're going with the vaping system because you did away with the smoking. Smart move. Again, you know, I'm willing to help her. I want to get you there, but I just cannot open this door and allow everybody and his brother. Do we really need 15 grow fields, Senator? I'm scared to death of that.
I respect your point of view, Senator. We just disagree on this.
Okay, that's fine. I'm ready to kind of go through your bill. If we're ready for that,
Sure.
I guess
Yes, sir.
we probably need to talk to the leaders and see what they want us to do. I'm happy to do whatever they want to do.
Senator, you continue with your questions, correct?
Yes.
Senator
I am
McCormick.
continuing, yes.
Yeah, so he's questioning at this point.
I yield to my friend from McCormick.
So
Thank
we'll
you.
continue.
And I thank you for the courtesy that you've provided me answering these questions for us. You would agree with me if do we have to call this compassionate care? I mean, I'm okay calling it compassionate care for this side, but I'm not really ready to call that compassionate care for that side.
For that side being the Cheech and Chong.
Yeah, that group.
I guess what I would say to you, Senator, and maybe we're going to disagree on this, is that those that want to smoke it illegally have access now. This is providing access for individuals who don't want to break the law and don't want to possess it illegally. So this bill is designed to appeal to them. I'll wait for...
Okay. All right. Compassionate care, do you agree with me if even one of these kids die that we've talked about here and has an episode, a psychiatric episode, and dies from a psychiatric episode or whatever, that for that family, that's not going to be a compassionate care circumstance?
I would agree that that would not be
Those
compassionate.
people are going to suffer.
They would.
Okay. And so, or if any of these children ages 18 to 25, while their brains are still developing, and you would agree with that, would you not, that the brains are still developing and marijuana has been deemed to be dangerous to the 18 to 25-year-old period people?
And I had that conversation with the senator from Charleston as to and this is my reasoning, whether you agree with it or not, but this is my reasoning, that before you reach the age of majority, okay, at 18, there's parental involvement, so there's some sort of a check and balance on the access to medical cannabis. In that window of time between 18, when you reach the age of majority, and 25, we felt like that there was a rational basis of treating them differently by requiring 2 certifications because of the unique position those individuals are in as opposed to individuals older. You know what? We could strike that out if you want to. Okay, if there's serious concerns, I think it withstands equal protection analysis. But if there's concerns by this body about equal protection treatment here, we can take that out. That's the reasoning for putting that in there.
They're taking out those 18 to 25s. I'm desperately worried about that group. My son was in that group. Okay.
Yes, sir.
And he, you know, you can say it's not a gateway drug. I know it is, Senator. And so all I'm saying is that, you know, let's make sure that it is a Compassionate Care Act. I like the idea of having comedy with our federal brothers and making sure that whatever we do, if we can, is to make sure that our laws mesh.
But, Senator, I guess I would say this. Can you point to any indication where the federal government believes that the states aren't acting in terms of comity and passing these medical cannabis laws? Because I think there's evidence of the contrary. Otherwise, they wouldn't be passing this budget proviso saying they can stand.
Well, you know, the law is the law, okay? So, I mean, I'm all about following the law. I mean, my oath says that, you know, when you look at the Supremacy Clause, it says that state legislators and state judges are under a constitutional requirement to follow the law as it is written. So I want to be that completely. I don't want to change that or in any way. And so whether the federal government is doing their job in enforcing it, Senator, I know that the CSA is on the books, just like our law is on the books.
And I've done the best job I could, Senator McCormick, from explaining how there's no express preemption in the CSA and how there's no implied preemption either. So I've done my best to try to explain why I think it's not filed to a federal law. You and I disagree on that. I respect that.
Thank you, Senator. That's all I have.